Hi everyone, and welcome to today's webinar, Self-Help Reimagined, presented by Lois, Lupica. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the author. Information is current as at the 11th of June 2019. Today, we are fortunate to have Lois Lupica as our presenter. Lois is the Maine Law Foundation Professor of Law at the University of Maine Law School and a Fulbright Senior Scholar at the University of Melbourne Law School. She is in Melbourne for 4 months, where she is examining the strategies used by legal aid organisations and community law centres in Australia, as well as sharing her research. I'll let Lois tell you more and talk to you again at the end of the session.
Thank you, Amanda. And thank you all for being here and expressing interest in this topic. So as Amanda just said, I am a professor of law, and I am going to describe today a research project that I am in the midst of. And it started out of the reality that in the United States, the dominant form of legal assistance provided to people of low income and low assets is self-help material. And as a result, there's lots of self-help material out there. But we recognized, and I'm working on this project with 2 colleagues, Jim Greiner from Harvard Law School and Dalia Jimenez from University of California, Irvine. And the 3 of us, when this project started 7 years ago, recognized that there is a significant difference between being able to access materials and being able to deploy the information that's contained in the materials. So we set about to really think hard about this issue of deployment. And we recognize that as consumers, we are expected to deploy all sorts of information that was formerly left to the hands of professionals. So what we as consumers are expected to do is understand health at a level that is beyond the typical person's health-related knowledge and background. We are also expected to invest our own retirement money, at least in the United States. So we're supposed to be able to understand what is a smart investment given our particular circumstances, and there's self-help material out there to help us. And in some instances, we are also expected to put together our own furniture and shelving and so on. But going back to the issue of legal self-help materials, the current state of self-help materials that are available widely still use inaccessible legal jargon. They're text heavy, they lack visual imagery, they lack advanced organizers, they fail to provide information about the processes that the user has to engage in, such as conducting a negotiation. They fail to set forth the details that we all take for granted about what to expect in court. And most importantly, they fail to help people overcome the inevitable feelings of shame and guilt that they experience when they are involved in for example, a debt collection action or a family law matter. And they fail to recognize that these circumstances are incredibly stressful for those who are in the middle of them. So we also recognized that the state of the art in legal self-help must change. But we didn't want to just come up with a great idea and throw it out there. We wanted to rigorously test the materials that address all of these issues and concerns. So the context of our study is financial distress. It is a widespread problem, both in the United States and in Australia. And we recognize that distressed debt has a lot of consequences, negative consequences that flow from it. And also, there are linkages between experiencing financial distress, and once people experience that, they are so overwhelmed with the issue that of where the school fees are going to come from and how to pay for the utility bills, that studies in psychology have shown that that kind of obsession and over concern with this problem leads to low mental performance, which leads to difficulty with decision making, which in turn can lead to other legal problems. So recognizing that, we decided that we were going to ask the question in our study, what types of interventions can help consumers in financial distress improve their financial lives? So when we ask this question in the United States, the answer is inevitably, well, why don't we have more lawyers help people who are in financial distress? But in the United States, we have always suffered from a dearth of resources to provide legal assistance to all people who need it. And from having spent almost 4 months here, I understand that to a lesser degree, but the same issue is true in Australia. So our legal aid organizations serve people who are at 140% of poverty. And the reality is that these organizations turn away 80% of the people who are eligible, and that doesn't even count people who are 141% of poverty or 160% of poverty, which is still at a level that is unable to afford market rate lawyers. The other theory about how to help people who are in financial distress improve their financial lives has been to provide financial counseling. So in the US in 2005, Congress mandated that every consumer who goes through consumer bankruptcy, before they receive the discharge of their debts, they take a financial counseling course. And the financial counseling course costs each debtor in bankruptcy $50. But Congress never tested whether or not these financial counseling courses improve people's ability to avoid over-indebtedness. And whether or not even these financial counseling courses, even if they're brilliant, are given at the correct time. So we decided we were going to test whether or not financial counseling, in fact, has the effect that Congress seemed to think it would. And the way we're going to do this is to conduct an empirical study. And we hope to come out of this study knowing where to deploy scarce lawyer time most effectively. At the same time, designing new interventions that are less expensive than lawyers. So here is a brief description of our study protocol. We have 4 treatment groups, and 50% of our study subjects are going to be or are being provided with full lawyer representation concerning every aspect of their financial distress. We're working with Connecticut Legal Services, which is essentially a community law center. And those lawyers are providing professional assistance to 50% of our study cohort. And 50%, the other 50% of our study cohort are receiving the self-help materials that we developed. And I'm going to say more about that in just a second. 50% of our study cohort are receiving the congressionally mandated financial counseling course, and the other 50% are receiving a placebo counseling course that we developed that was modeled, style, substance, length, method of delivery on the financial counseling course, except it's in food safety. So at the end of this study, we are going to understand the extent to which our newly reimagined self-help materials work almost as well, or perhaps better than full lawyer representation. And we're also going to have robust data about financial counseling. Okay, so let's go back to the issue of self-help materials. So we started this project by doing a lot of interdisciplinary research. We read literature in the fields of behavioral economics, public health, distance education, experimental psychology, sociology, cognitive psychology, to try to understand how, what work has been done to help people learn difficult concepts and help people act on this information, actually learn it so they can use it. So our methodology for the development of these materials involved court observations, cognitive interviews, and focus groups. For the court observations, my co-PIs and I spent hundreds of hours observing people self-represent in small claims court. We saw folks muddle through, not know where to sit or stand, be forced to negotiate with lawyers when they didn't know what to say or what to do. We saw them agree to things that we knew that they shouldn't agree to, and we learned an awful lot from that experience. With respect to the cognitive interviews, my co-PIs and I sent out hundreds of law students to the halls of small claims court with drafts of our materials to ask them whether or not they understood the way we were communicating things, they understood our directions, they understood our graphics, and then we came back with great feedback and went through the process again of preparing a second, third, fourth, fifth, and so on draft of these materials. So here's an example of what came out of one of our cognitive interview series. So we were trying to describe the concept of best evidence. And the three of us and our law students thought version 1 was really clever. And we sent folks out to the halls of courts to check with people who were dealing with debt collection issues and dealing with the concept of best evidence, although they may not have recognized that. And they didn't understand what this visual meant. Why is the paper smoking? They just didn't know what it meant. Version 2, we thought, was an improvement. We used a little more direct language, but the folks that we asked also didn't think that this was a really good representation. They couldn't then explain what best evidence means. Version 3 tested so much better. People were able to read the words and look at the graphic and tell us what they thought it meant, which in most instances was quite accurate. So now what I'm going to do is talk about our initial research and testing hypothesis and how in our materials we addressed what we discovered to be the challenges, the barriers to people being able to deploy professionalized legal knowledge. So our hypothesis is that when people are in financial distress, they are going to have trouble deploying professional legal knowledge as a result of the barriers that they are facing in the moment in that context. These barriers include cognitive, emotional, behavioral, and psychological challenges, debilitating feelings of shame, guilt, and hopelessness, a lack of self-agency, and the difficulty of making plans and implementing plans. So the first thing research has told us is that when people are over-indebted, that they face the barrier of shame and guilt. So that's our hypothesis. And what research has told us is that if you include an affirmation in your materials that are designed to get people to act and do something that's difficult. So the literature was in the context of weight loss, smoking cessation. If you include an affirmation that reminds people that they may be in a bad circumstance, but that doesn't mean they're bad people, the user is better able to take the next step and act. Again, we tested this in the courthouse halls, and people found it to be quite useful. Our initial reaction to this was a little skeptical, but after months and months and months of cognitive testing of some of these affirmations, we became persuaded that this was actually a useful tool. Our next hypothesis: when people have to advocate for themselves before a figure of authority, they face the barrier of a lack of agency. So in our materials, and you can see we use this protagonist, this character, the one looking at himself in a mirror. We call him Blob. And sprinkled throughout the materials are examples of Blob practicing advocacy before he gets to court, and then having greater sense of agency and being empowered when he is in the moment. The same idea comes through when people have to assert themselves in an unfamiliar and intimidating context. So we narrate Blob's practicing at home rehearsal for the time that he actually has to appear in court. And again, research has shown that if you practice something difficult, you're more able to have greater confidence, greater agency, and be more effective at the time that you have to do it for real. So here's another example of showing Blob that even if he's told that he has to negotiate with a creditor, that he has rights and he has the right to talk to a judge, and so on. So one of our other hypotheses is that when people face the barrier of uncertainty about what to expect or what to do in an unfamiliar context or environment, learning shuts down. That if they're thwarted at the very first instance, if they get a document in their hand that they don't fully understand what some of the language means, what some of the directions mean, they are going to be less able to hear the next message. And while, at least in this project, we weren't able to change any of the forms, we were able, and we did, translate a lot of the forms for the user to make them less intimidating. We also gave users previews of what to expect, how to get to the courthouse, where the parking lot is, what they had to bring with them on the day of court, and again, what to expect when they walk through the door, what to expect the waiting room to look like, and ultimately what the courtroom would look like, which also showed the person where they had to sit or stand. And the idea is that each one of these steps that the person has to take is going to be scary and intimidating. But if they got a preview of them before they arrive, well, the user suddenly has had a series of wins. And once you have a series of wins, you're feeling better about the process as a whole. And research has shown that if information in self-help materials fails people on the small things, then the barrier of trust is not likely to be overcome when they actually have to act in a way and follow directions that are more complicated. So again, with each form, we gave not only explicit directions with respect to the form, but specific directions in the text of the material, and no detail. It was too small or too seemingly insignificant for us to include. Again, we included a lot of graphics and previews about what the user was going to expect and what the situation was going to look like. So another one of our theories, people in financial distress because their bandwidth is consumed with the issue, as I said earlier, of scarcity, of worrying about the bills that are unpaid on the dining room table. Because of that, these folks face challenges with plan making and with goal setting. So our self-help material include tools to help users make plans and set goals. And the idea is that if you commit in advance to a particular action, you don't have to muster self-control in the face of temptation, which is so much harder to do when you have an overtaxed bandwidth. So we also found in the literature that if goals are specific and proximate, they're more likely to be accomplished. So for example, if X happens, commit in advance to do Y. So we included a lot of examples in our materials of the user committing to responding in a specific way to a specific circumstances. And these examples and the advice to have a plan for when X happens eliminates decision-making in the moment, when the moment may not be the best time to actually make a decision. The literature also tells us that if goals are framed positively, they're more likely to be accomplished. So in the materials, we include examples of how to frame their goals positively. Planning prompts. So there was a really interesting study that showed that people were 70% more likely to to show up for their colonoscopy if a Post-it note was included in their reminder notice than if it wasn't. So we thought, this is a great idea. So we're including Post-it notes for events that occur in the future to help the user have a tangible reminder of a plan that they have made. What we also found in the literature is that if you use encouraging words and pictures, people are more likely to stay motivated through a difficult or lengthy process. Again, great examples in the public health weight loss literature. So throughout our materials, we have now Blob running to the finish line. The graphic on the right of the three mountains that Blob has to scale. In the beginning of a particularly difficult task, filing for consumer bankruptcy, we had Blob on the first mound, so he made it to the first point. In the middle of the process, we have him on the second mound, and at the end of the process, Blob has reached the summit and has really accomplished something. We also found in the literature that if self-help materials include relaxation exercises, anxiety can be lessened through a stressful process. So at particular points in what we recognize to be stressful processes or a stressful event, before they have to negotiate with creditor, before they have to speak before the judge, we offer some deep breathing exercises and the suggestion, if they close their eyes for a few minutes and try to lose their thoughts, that they're going to be better equipped to do what comes next. When it comes to legal knowledge and information processing and learning, we recognize that there is a difference between conceptual knowledge, which is what we learn in law school, what all professionals have about in their area of expertise. Now, we have to understand underlying principles and see connections and relationships between ideas and interpret and analyze concepts. Well, a user of self-help materials, for the most part, doesn't have to have a lot of conceptual knowledge about what they're doing. What they need is procedural knowledge. They need skills to negotiate, to speak up when it's their turn. They need to know what comes first, what comes second, what comes third. They need to be provided with action sequences. Do this first, do that first, do that second, and do this third. So we included a lot of procedural information in our materials and as little conceptual information as possible. So the idea is to provide less why they have to do something and more this is what you have to do. We also included a number of scripts for the user to read at the appropriate moment, making clear that they may have a general understanding of what they're saying, but beyond that, that's not necessary because the judge is going to understand what dismiss this case with prejudice means. And so if people have a script to read at the right moment, we've seen through court observations an incredible feeling of empowerment coming through, a real sense that they are participating in this process in a way they never thought they originally could. There are times, however, when conceptual knowledge is necessary. And when it's necessary, adult learning and learning research has told us that the use of analogy and imagery is helpful in explaining complex conceptual topics. And so, for example, this is how we describe the statute of limitations. We described hearsay, which is a concept that most of us struggled with in law school, but the use of mnemonic and the picture of an ear. There are ways of breaking down complex concepts. As you can already see from this presentation, we use a lot of imagery. And the research tells us that if imagery accompanies a simple narrative, it can help explain complex concepts. It can direct the user as to what to do next. It can reinforce ideas, and it can also entertain the self-help user, again, while they're going through a lengthy process. So the image in the middle of this slide accompanied a discussion about filling out a bankruptcy form that required the calculation of their annual income if they only had their monthly income. And then there was another step. But again, the images are used as a supplement, as an augment to simple language. The literature also told us, and this seems to surprise many people, that stick figures should be used rather than detailed photographs or drawings. The literature says that the detailed photographs or drawings are distracting when someone's bandwidth is consumed by other stressors. So if you're looking at this photograph, you see the white of the law enforcement officer, you're looking at the individuals, you're looking at the lighting, there's so much detail in this picture, whereas the stick figure drawing on the left only has the simplest information and only the information that the user needs to know if the point of including it is to give the user a preview of what they're going to see in court. Again, the literature tells us that if checklists are used, it helps the user keep organized. So we included a lot of checklists. If there were multiple steps that the user had to take, and advanced organizers if there was a lengthy process that they had to embark upon. So this was a 4-part series of how to defend yourself in court. Part 1, you go to court. Part 2, here's some procedural information and some substantive information about your rights. Part 3 is what to do in court. And Part 4, this is what you should take to court. Obviously, legal jargon should be avoided, and complicated processes need to be simplified. And it really did startle us how frequently legal jargon wasn't avoided, continues to be used in self-help materials. And even when something complicated has to be described, it's not useful just to include a definition. It's useful to include an explanation and some examples, all using short declarative sentences and simple language. All of our materials were tested using the Fleisch-Kincaid testing method, that they were 5th grade reading level or below and written in a conversational style. Repetition is considered a positive thing when you're trying to teach adults. So language, this may not be what you're used to reading, but this is the way one would speak if you're explaining something complicated to someone who is in an unfamiliar circumstance. You can always tell your side of the story to the judge, even if the judge says that it will take a long time to finish the case if you don't settle. If you want the judge to hear your story, the judge has to listen. So we, after researching communication theory, we drew on this research at the level of the page, the sentence, and the word. So we used the active voice and the present tense. We placed the main idea before the exceptions. I can't tell you how many materials I read that started with the exception and then got to the main idea. We gave lots of examples of how one would follow directions. We liberally used headers. We used lots of white space, and we followed various font conventions. So here's another example. If you don't want to agree to a deal, you don't have to. Tell the lawyer you want the judge to decide, then go back into the courtroom. You might have to wait a while before it's your turn. That's okay. You have the right to see the judge. And this came out of us watching the judge sort of encourage people to settle, because otherwise they were going to be there all day. You know, if that wasn't in the user's best interest, they need to know and understand their rights. So in summary, we focused on principles of simplicity. We provided shortcuts and prompts. We made self-improvement behaviors the default. We included various tools to improve users' self-control and follow-through. We endeavored to keep people engaged when they were performing difficult tasks. And we recognized continuously and regularly that our audience was overtaxed, stressed, overwhelmed, and in many instances, we're dealing with a low literacy and certainly an unfamiliar population. So just to give you a little background about the study, as I said, we started this 12 years ago. It took about 5 years to complete all of our self-help materials in every aspect, that address every aspect of financial distress. So it includes defending a credit card, debt collection action, fixing your credit card, negotiating with creditors, dealing with utility debt, dealing with medical debt, which is a very big deal in the United States, addressing student loan over-indebtedness, filing a simple Chapter 7 bankruptcy, special materials for veterans. There were some programs for veterans, just to name a few. We had to raise money for this study because we were paying for legal services time, and we started our field operation about 2 years ago. We have another 8 to 12 months. Currently, we have about 800 study subjects enrolled, and we should be done with our field operation in 2020, and we will begin data analysis. Just going back to what I said in the beginning, what we're going to be measuring is not just whether or not people use our materials, because we know they're using them because we're watching them in court, but we are using the objective metric of credit attributes and credit scores. So we are looking at 200 credit attributes for each study subject 2 years before they enrolled in the study and 3 years after. We want to see whether or not these individuals' financial lives are improved. We're also administering a series of surveys, including a physical and mental health survey, to look at their physical and mental health before they enter the study, when they were in financial distress, and after they leave the study. And as I said, we will begin our data collection and analysis in 2021. So that concludes my presentation, and I am happy to take questions from anyone who has questions.
Thank you so much, Lois. So if anybody has any questions, if you can type them into the little question box at the side, and then I'll read them out for Lois to answer. While we're waiting for you to type in your questions, I'd like to thank everyone for attending this webinar and give a big thank you to Lois for such a great presentation with so much practical information on how to help clients. I'll give you a minute to type in any questions that you might have. We've got a comment that says, some great ideas, thanks for sharing.
That's an easy one.
Yeah, don't really need to answer that one.
You're very welcome.
We have another comment. It says, very, very interesting and helpful presentation, great research. That's also an easy one. Thank you for that.
You all are throwing me softballs.
Okay, we have a question now. Oh, okay, we have loads of questions.
Okay.
All right. Are you aware of similar research applied to areas other than financial situations?
To our knowledge, and we did some pretty quite extensive research, there's never been a randomized control trial testing anything like self-help materials or legal education materials or anything like this, no. There have been a number of studies where people are asked whether or not they liked the use of an intervention, something that would help them, like an app, but never tested using the objective metric of whether or not outcomes are improved.
Right, that's really cool. So your research is a new area.
Yes.
All right, the next question was, Is there a difference between a layperson prosecuting a claim and a layperson defending a claim in the type of material which assists? I'm not sure if you looked at this, but if you know anything that's relevant.
Yeah. That's a really interesting question because, a lot of people who are creditors are small businesses and may not be sort of in the same at the same level as Bank of Melbourne or Citibank, but that's not what we're looking at. I think if our study shows that these materials are effective, if and what we hope happens is that that's exactly what is shown. And after that, what we plan to do is invite people to take advantage of our research and develop materials in their field and their area. And I would imagine they would be quite useful for someone in a similar situation, sort of a not necessarily a repeat player in the system, the way credit card debt collectors are, but there certainly could be a plaintiff, for example, in a debt collection action that's a one-off plaintiff. At the same time, there's a one-off defendant in that kind of proceeding. But again, that's not what we're looking at in this study.
Yeah, I can definitely imagine that theoretically it would be helpful. Our next question was whether you think it's better to have information in a limited size, about 2 pages maximum, and a lot of documents, or having one large document that covers the whole issue.
Okay, so that is also a fantastic question, and I had a long conversation. I've had many long conversations with folks in community legal education who their convention for the development of fact sheets is 1 page front and back. And I just went through a workshop at Victoria Legal Aid where the first direction was, let's throw that convention out, because I looked at some 1 page fact sheets and they didn't have the information that a person needed to either orient themselves to what they were about to do. It didn't have action sequences. So if a process involves a lot of steps, including previews of what to expect, descriptions of the kind of documents they need, what to anticipate the other side will say, and all of the tools that a person needs to act on these directions, including plan implementation strategies, including affirmations, and including directions, step 1, step 2, step 3, step 4. My view is that that kind of information is so much more valuable, even if it is on multiple pages, than sticking with a convention that doesn't, of a single page that doesn't give the person the information that they need. So we went through at Victoria Legal Aid the process of taking one of their 1 page fact sheets and applying some of these best practices that we discovered. And it turns out that if we clearly defined who was getting this fact sheet and when they were getting it, there was very little information on the double-sided 1 page fact sheet that the person needed. So even though some of our drafts were longer, they were far more useful, which was the consensus of the group. So I would say that at least if you're talking about materials in written form, it's less important that they're short and more important that what's in there is actually deployable, which means the person will act upon the information.
Thank you, Lois. That's a great answer. We had another question that was related. It's whether it matters if they're A4 size information or
A4. I'm sorry. I don't know that as a as a conventional term, but I know what you mean.
Oh, sorry. I don't know if it's an Australian
Yeah.
term.
Yeah, it's an Australian, I think European. Yeah, we have 8.5 by 11 or 11 by 13.
Oh,
You know, so we um, we decided to use paper for the reason that the study first took place in Maine, and Maine doesn't have high it doesn't have universal broadband. That's the term I'm thinking of. Universal broadband. So we couldn't put these materials in the form of a website. If these principles are demonstrated to be effective, then this information can be in a variety of forms. It could be on a web page. It can be in a booklet. It can, so it's, we're not so much focusing on the form of the communication of materials. For our purposes, they're an 8.5 by 11, which I think that's your equivalent of A4. And there are in binders with advanced organizers and with tabs and so on. We're really focused on what's in the materials rather than the fact that, you know, it definitely goes in the con column that folks are getting a thick binder of information. It goes in the plus column if they're actually able to deploy the information in the thick binder.
right. So the paper size isn't really an issue. All right.
We're just not, yeah, I mean, we're just not worried about that because we have so many other principles that we're testing.
Awesome. Thank you. We had another question about whether you had any recommendations that relate to self-help materials for clients in vulnerable situations like experiencing domestic violence or significant mental health issues.
So I think, I mean, it depends upon the degree of mental health. What our materials do is try to address someone who's in a very stressful situation. So again, we identified the area of financial distress as the one we were going to look at. But I've also been working on a project in the area of family law using similar principles. So I'm not an expert in domestic violence, and there may be various communication tools that are better for communicating with people in that circumstance. I know that in apps that I've worked with people in developing for people experiencing domestic violence, there's always an exit button. So I think like every project, you've got to start with subject matter experts when you're developing interventions. I'm a subject matter expert, as is my co-PI Dahlia, in financial distress for consumers and consumer bankruptcy. And so again, if these principles were going to be translated for slightly different audiences, then I think you do need someone with an expertise in the specific needs of that audience.
Right. Yeah. It's your materials are for helping people in stressful situations, but there might be sort of additional factors when it's a different
Correct.
of a stressful situation.
Right. So I guess, you know, that would go into step 2 after we have our data demonstrating the utility of these principles.
Yeah. All right. We had another question about whether any of the self-help materials were translated for or tested with people who don't speak English.
Again, great question. They absolutely will be if their utility is proven, but at this point, no. Unfortunately, one of the criteria is that they have to be able to read and speak English at least the 5th grade level, but that's an obvious next step. And you know, in the U.S., the next obvious language would be Spanish, but For example, in Maine, my kids' school materials were translated into 27 different languages because of a large refugee population that we have. So yes, that is absolutely essential for any materials to help consumers, but not for purposes of this study.
Right, so it's definitely a potential next step.
Yes.
All right, we've had some questions about whether you might be able to share some of your self-help documents, or we had a question about sending out the slides. We've sent out the slides to all of you, but I can send out a specific slide. Yeah, whether it would be possible for some of our attendees to have a look at some of the self-help documents to show their colleagues, etc.
Sure. Yeah, I've got some that I can share with you, Amanda. I'll send them to you, and then you can distribute them to whoever. I mean, obviously they are. Our study takes place in Connecticut, so they're tailored to Connecticut law. I would ask that you not use them until our study is completed, but obviously Connecticut U.S. law is not going to be very helpful. But you will see the execution of many of these ideas that I just described.
Yeah, definitely. They would have examples of all the techniques that you talked about.
Yes.
All right, we had another question about how you gathered evidence, whether you can say more about the evidence you gathered, about how you observed the materials used in courts, because a major problem for those of us trying to develop information and self-help materials is that we don't have resources to evaluate the effectiveness of the help provided. They develop materials that they believe respond to legal issues that they've observed clients have from their past experience.
Yeah, so the cognitive testing that I described involved us coming up with a draft of materials, like defending yourself, or let me give you an example, negotiating with creditors. We took this, what we thought was a pretty complete first draft, and had a team of student testers, and you're absolutely right, it takes a huge amount of resources to be able to do this kind of study and evaluation. And the students went through a series of questions. Can you describe what this means? Can you tell me in your own words what this means? And then there was another question which we found in the literature. Okay, so what do you think of these materials? Do they give you the information you need? And then ask them, what would someone not as smart as you say about this information? And then the students came back and wrote lengthy memos about people's reactions to various information found in the materials, and they gave us feedback about what worked and what doesn't. So that was the research, the testing we did in order to come up with our final drafts of our self-help material. The testing that we're in the midst of, our field operation, is following these individual study subjects, as I said, 2 years before they entered the study. And the point of entry is that they're sued on a credit card debt collection action. And essentially looking at so at least in the US, and I'm not sure how it works in Australia, but we all have credit records. So look at their credit records, and presumably they're going to look pretty bad when they enter the study. What we're hoping to see is an uptick in their credit scores and credit attributes. So whereas they had 6 individual debts in collection, at the 2.5-year mark, maybe they're going to have none in collection or only 1 in collection. That shows that these materials improved their financial health because they were using them to address all of their financial issues during this period of time. Again, It's a really complicated and expensive field operation. We ended up raising $1.5 million to American dollars to do this study. We got a fairly large grant from the National Science Foundation, which is a governmental entity, and the rest of the money, so that was about a third. The rest of the money came from private foundations. So while we were drafting the materials and testing them and going back and redrafting, we also had this major fund raising effort on the part of myself and my two colleagues. So it's really hard for legal aid lawyers and community law centers to do this kind of evaluation. So what I would say is, if you're interested in understanding if what you're doing works, find a university partner. There are lots of law professors and lots of social science professors who love to test things. And this is an area that I think needs a great deal of evaluation, because, as I said, I think we're relying on materials that aren't necessarily effective, that don't necessarily help people solve their problems, that are written by lawyers and for lawyers. So I hope that answers your question. I'm happy to answer a follow-up.
That was lots of information. It's definitely lucky that we've got the results from your study to give us some information, considering how labor intensive and difficult it was to get those results.
So the final results are not available. We still are in the middle of our field operation, but we will have the results of whether or not and when these materials are effective. So we may find that nothing substitutes for a live lawyer in court. And so at the point where the person is in court, for example, we might find that having a lawyer is much more effective. But we may also find that people can do some tasks on their own. They can clean up their credit report. They can negotiate out of court with creditors just as effectively using our self-help materials. I would consider that an absolute win, because there are some things that no one's ever going to be able to afford a lawyer to do, like cleaning up your credit report. I mean, that's one of the professional tasks, and that's not an easy thing, as I discovered when I put together these materials, but we're expected to do it on our own. So when we have the data about what works, what interventions work best and when, I hope to come back to Australia to share it.
Great, well, I'll look forward to that. We just had a follow-up question about how you gathered the data, whether you observe clients using the materials in court.
We have anecdotally, so it's not part of our quantitative data collection, but we are quite curious and interested to see how people use them. And so we have, I personally haven't seen it, but research assistants have come back with really detailed memos, as I said, explaining what happened when someone read a script of ours, and what happened when they put forth the defenses that we suggested might be available to them. And reading these really brought tears to our eyes, because we've seen, as I said, we spent so much time in court watching people really flail in these unfamiliar situations, and to read about people having tools that they can actually use, and watch them use them effectively, or in our case, read about someone watching them use them effectively, is very heartening.
Awesome, thank you. So that's all of the questions we've got, apart from, I'll get back to some of you about the materials.
Yep.
So yeah, that brings an end to the presentation. Thank you so much, Lois, for
you're very welcome.
All of your answers. Everybody was definitely really interested in learning more. Yeah, we'll look forward to hearing the results of your final research.
Well, thank you. And thank you again for listening and for having me for this seminar.
Thank you so much.